Alrighty, good evening, everyone. Welcome to week 6 of administrative law. Constitutional law. It's only Tuesday and it's already been a big week. Constitutional law. We're definitely here for constitutional law. Um, interesting topic this week. Probably one that many of you will find frustrating. And if you're sitting there after doing the readings and watching the lecture videos and just feeling like I'm still not quite getting this, that's normal. Um, Even the High Court judges can't seem to quite figure out intergovernmental immunities and can't reach a consensus on what it means and how it should apply. So if you're feeling a bit lost, that's completely fine. As much as we can in tonight's tutorial, we'll be trying to make as much sense as we can of this particular area of law. But before we do that, I wanted to acknowledge everyone's efforts in completing the first assessment, which was due yesterday evening. In a subject that's as tough as this, that first assessment is always a difficult one to get moving. And I know for some of you, this is your first subject studying at university. So I wanted to pause and acknowledge the effort that everyone's put into completing that assessment. So well done to you all. The question 2 definitely hurt my brain. Okay. Yeah, it's, they're thinkers, that's for sure. They're off with the marker now, so it'll be aiming for a 2-week turnaround on those, but I'll keep you updated with the progress on that one as that comes through. Attention, of course, now starts turning to the second assessment, which is the blog post and that's working with a partner. So if you haven't already, check out the spreadsheet on Moodle to find out who your partner is. I'd very much encourage you to try and get in touch with them sooner rather than later. And if you're having any issues getting in touch with your partner or anything like that, absolutely feel free to reach out and let me know, and I can help get the ball rolling on that front. Or, sometimes between census date and now, some people will have withdrawn from the subject as well. So I can check in on those sorts of things too. So definitely reach out early, have a conversation with your partner around how you'd like to break down the work, what your expectations are of each other and of yourselves, letting each other know the time commitments that you've got. Not everyone has any hour of the day to dedicate to their studies. People have got work, people have got family, people have got all sorts of things going on. And I find that people are very good at working around those commitments, but it just requires that you have a conversation with each other at the beginning, saying, here's what I've got going on in my life. I'm committed to making this assignment work, but I'm only free on the weekends, or I'm only free in the evenings, whatever it is. Just being really upfront with that one. We'll spend some time in the coming weeks looking in a bit more detail about sort of what a constitutional law blog post looks like, because it's obviously a very different way of thinking about things compared to a response to a hypothetical scenario. But for now, what I'd like you to be doing is sort of thinking about these the differences in ways that people interpret the Constitution and get at some of these deeper ideas that underpin the Constitution. And there's almost no better topic for that than federalism. And in tonight's tutorial, looking at intergovernmental immunities, we've got a very deep and rich history of judicial disagreement about what on earth the relationship between Commonwealth and states should be, and how much they can interfere with each other, and what all that means. So we've got a hypothetical scenario to work through this evening that I think will help highlight some of the key concepts that we want to be talking about. But before we do that, I wanted to share, I suppose, a bit of I've called it a cheat sheet. It's not really, because I think, it doesn't stand on its own. You very much still need to be doing the readings and listening to the recordings. But just something that might help you make sense of the different ideas and the themes that play across the history when we're talking about intergovernmental immunity, so that when you're confronted with a problem of, okay, here's one level of government trying to do something that impacts another level of government, how do we start to sort through this, and how do we start to construct something that resembles an answer? Because one of the things that you will have noticed is even when judges broadly agree that there should be an immunity, or that in principle an immunity looks like, let's say, a ban on discrimination of the states, even then they don't quite agree on exactly what that looks like, or how it plays out in practice. So this is sort of a guide, and I'll pop it up on Moodle tomorrow with the recording of tonight's tutorial, so you've got access to this to refer to at a later date. But it's just to help you gather your thoughts about where you might start in pulling together an answer to an intergovernmental immunities question. So step one is to think about at what jurisdiction the law or the legislation is operating, and which jurisdiction is being affected, right? So is this a Commonwealth law that impacts the states in some way, and the states are seeking immunity, or is this a state law that impacts the Commonwealth in some way? Because even then, it's this idea of intergovernmental immunity. There's a gap between which direction the immunity applies in. So being really clear in your mind, okay, we've got Commonwealth law. Is it a particular state, or is it a group of states that are seeking immunity, or is it a state law that might impact the Commonwealth in some way? That's a really important starting point. From there, let's say you've got a state government that's seeking immunity from Commonwealth law. The next thing that you'll want to do is to establish that Commonwealth law is valid. So thinking about the ideas that we've talked about in previous weeks around, is this, can we characterize this as a law with respect to something that the Commonwealth has a head of power or legislative power to make laws with respect to? So going through some of those ideas of, maybe it's external affairs powers, maybe it's defense powers, whatever it is. If it's not valid, then, of course, the states will be immune because it's not a valid law. So the issue doesn't really arise. Let's say it is a valid law. Then your starting point in thinking in a purely pragmatic approach to intergovernmental immunities, your starting point is I wouldn't look at anything further back than Melbourne Corp. So I wouldn't worry about engineers. I wouldn't worry about anything pre-engineers as well. It's all important context, and there are themes that cut all the way through. But if you're struggling to wrap your head around intergovernmental immunities, start with Melbourne Corp, and don't worry about the stuff that's come before, because it's all the disagreement that's come since Melbourne Corp is at least based on the idea that Melbourne Corp had intergovernmental immunities right, in the sense that there are some intergovernmental immunities. So start with Melbourne Corp. The disagreements that have flowed from there have revolved around, is the Melbourne Corp principle basically, is it one limb or two limbs? So Melbourne Corp broadly presented the idea that states will be immune from a law that discriminates against them or interferes with their functions in some way. And Justice Mason in Queensland Electricity put that a bit more tangibly as there'll be a prohibition against discrimination, which involves placing the states some sort of special burden on or disability on the states. So looking for some kind of discriminatory element, or even if they're not discriminatory, if they've got general application, they operate or to destroy or curtail the continued existence of the state. So the law is of general application. It's not targeting the states or one particular state, but in practical effects, it's got some impact or limitation that actually makes it very difficult for state governments to fulfill their function as a government. Those are the idea that there's two limbs. That was consolidated in Austin as just one limb, and the focus being a prohibition on undue interference with the operation of state governments. And so the view in Austin was discrimination might be a form of undue interference. So if a law was discriminatory, it could still infringe the intergovernmental immunity, but it's okay, thank you. So I've just frozen. I'm not quite sure how long I was frozen for. So had I finished talking about Queensland Electricity and moved on to Austin, or was I still on Queensland Electricity?
I think you had just started talking about Queensland Electricity.
It just started. Oh, okay. Sorry about that. All right. So we've got two limbs in Melbourne Corp, and then that gets, I suppose, restated, but a little bit more neatly in Queensland Electricity by Justice Mason. Again, as two limbs. So first limb, you can't discriminate, or the Commonwealth can't discriminate by putting some kind of special burden or disability on the states. Or even if a law is of general application, so it doesn't target a state or multiple states, but in practical effect, it has some kind of causes some issue with the existence of the states or their ability to function as a government, then that will be a problem as well. That two limb idea then gets reformulated in Austin as just a one limb, the one limb being prohibition against undue interference. So really focusing on that second limb from Queensland Electricity. And the idea was discrimination against the states isn't its own separate limb. It's just something that would be undue interference and would be something that would put a special burden on the states. That's a position that hasn't really gone away. And so there's an argument that the one-limbed principle in Austin is still good law. And we'll talk about how that applies in practice in a minute. But Chief Justice French in Clark gives us another way of thinking about this, and it's the advantage of Chief Justice French's judgment in Clark is that it actually ties together a lot of the debates that have been happening both post Melbourne Corp and indeed before it. And so, and his argument is that, it's always, the implied limitation has always been evaluative. So it's never been something that's cut and dry. It's always been, let's look at the law and let's look at what the impact actually is and decide whether that's problematic or not. So it's not something that the sort of the earlier tests and these limbs, they were leading down a pathway where it tended to be you either have it or you don't, and it becomes a bit yes or no. Whereas what Chief Justice French is saying is that it's really, we actually need something that's got, it accounts for a bit more of the grey area, and it can look at, the key question is the law inconsistent with the status of states as independent entities under the Constitution? And how do we address that question? Well, we think about a range of things. So whether this law singles out one or more states, that could be a problem. Even if the law doesn't single out a state, it's of general application, but it imposes a particular burden or disability on the states, that could be a problem. Whether it affects their capacity to exercise constitutional powers could be a problem. Whether it affects their exercise of their functions could be a problem. What is the nature? So does it have a big effect? Does it have a small effect? And what's the subject matter of the law? Does what this law is about, so going back to these characterization ideas, does that matter as well? Some areas of law might have might permit more infringement on state powers than others. And then the key part, none of these factors considered separately will necessarily be determinative of the application of the limitation. So instead, we're taking all of these questions together and running through them and saying, okay, cumulatively, is this something that is inconsistent with the status of the states or not? And it's yet another departure. It's yet another way of thinking about this relationship between the Commonwealth and the states. But what I like about Chief Justice French's approach, and one that hopefully you find useful as well, is that it gives you a really clear list of things to talk about or think about when evaluating a law that might be an issue. So where the previous approaches around what does undue interference look like? How extreme does something have to be before it curtails the state's capacity to function as a government? There's cases and there's precedents that give some guidance on that, but they're still very nebulous topics, whereas Chief Justice French's approach gives you a clear list of things that you should think about. You can think of it almost as like a checklist, in that you'll look through and you'll say, okay, it doesn't single out a state, but it's of general application and there's some problems there. It doesn't seem to affect the capacity of their states to function, though. Blah blah blah. You can go through them all, and as a result of going through these sort of 6 factors, you can reach a considered conclusion at the end about whether this seems to be something that's inconsistent with the status of the states or not. So if you're feeling lost about intergovernmental immunities, my suggestion would be Melbourne Corp as the starting point, because that's the important history. But I would also suspect that for many of you, if you're wanting something that's a bit more grounded and a bit more tangible, Chief Justice French's judgment will get you a long way there and will give you something to think about that is a lot clearer than these earlier debates of, is discrimination its own principle, or is it just wrapped up in the same principle or limb? How do we understand the relationship between these things? I would focus on Chief Justice French as a starting point. And we've talked in previous weeks about kind of having that anchor point that you can start with and then keep coming back to. I'd say Chief Justice French and Clark is a good spot to begin your exploration there. We'll go over to the hypothetical in a moment and we'll see how that works in action. If you're dealing with, so if back at step 1, you've said, look, we're actually dealing with a state law here, and the Commonwealth wants immunity for that, then what we're thinking about is what can states do to regulate Commonwealth functions. Gone again. Okay. Where did we get to that time? It's hard with all the blanked out screens. Usually I can see when everyone else seems frozen. I know that it's actually me frozen. Okay, start on the next topic. Cool. So we made it through Chief Justice French and Clark. That's good. All right. Let's say you had at step one, you had a Commonwealth, a state law, and the Commonwealth was arguing that it should be immune from it. So we're thinking about what can states do to regulate Commonwealth functions. Here we're thinking particularly about Sigmatic as a starting point, and also Henderson's case, and trying to get a sense of whether the state law is trying to regulate activity versus the capacity to govern. So a good example might be and this is a very rough approximation of what played out in Henderson's case. State governments can regulate what landlords can and can't do, where the Commonwealth government acts as a landlord, where they're leasing property. Their activity as a landlord can fall within what the states can regulate. But the states can't affect the Commonwealth's capacity to govern. So they can't tell the Commonwealth properties that they can and can't lease, or dictate to them who they could or couldn't lease to, those sorts of things. The argument would be that those go to their capacity to govern rather than regulating the activity itself. So thinking about, is this something that is of general application and it's about activity, or is this focused on trying to regulate what the Commonwealth, what's in their capacity as a government? So distinguishing that, there's been less judicial disagreement on that one, so it always makes it a little bit simpler. But that's a not so brief overview of the state of the law. Before we look at this week's hypothetical, was there any questions that anyone wanted to raise on that one in sort of the general overview terms? Excellent. All right. Well, let's look at that in practice then.
Jacob, excuse me, I have a question.
Okay.
In that kind of analysis, shall we distinguish when on the started arguing between express and implied immunities?
In what context? Sorry. Sorry, you just on mute there, Vladislav.
Excuse me. In the context of enumerating, for example, clause section 114 of the Constitution about impossibility to impose any tax on the Commonwealth. So it is kind of express immunity, if I'm not mistaken, of the Commonwealth. What do you think?
Okay, so in dealing with a state law that tries to tax the Commonwealth, whether you should take the approach of Section 114 or whether you should go the implied intergovernmental immunity and go with the precedent of under Sigmatic and that sort of line. Is that what you're the safer approach is to go express rather than implied. because that tends to have at least a little bit more certainty attached to it. And, 6 weeks into constitutional law, you already know that even if something's expressly written in the Constitution, that doesn't make it certain by any means. But I would go express where possible. The other option is to present 2 arguments in the alternative. So you might say where there was something that where you had a scenario where there was a state tax on the Commonwealth, you might say, look, under Section 114, it's no good. But failing that argument, you might even say that this tax affects the Commonwealth's capacity to govern, and so even under the implied intergovernmental immunity, it's still problematic. So you could say both, but I would favour starting with the express in most circumstances if you can. Well, any other general questions? Alrighty, so this week's topic, or hypothetical question, I should say, we've got a new law, the Ex-Service Personnel Reintegration Act, and it calls on all major employers to do their part in transitioning ex-service personnel back into, I suppose, civilian employment. And the Act sort of sets out 4 key things. Employers have to give priority to ex-service personnel when employing new staff. Where they're employed by states, the states have to pay ex-service personnel a minimum wage that gets set. State governments have to give priority to ex-service personnel in promotion decisions, and state governments have to ensure that all that their departments employ all ex-service personnel who do not have full-time employment by a particular date, even if that means displacing other employees. And so the states commence proceedings. They can see that defence power supports the law itself, but they're deeply concerned about these laws, and Queensland and Victoria are especially worried because they feel like that's going to hit them the hardest, because most former service personnel have returned to those 2 states. So the scenario puts you at give judgment in this case, which gives you a bit of flexibility, really, because it's not necessarily apply the current interpretation or tests of the implied intergovernmental immunity, insofar as that's something that's settled. It's actually broader than that, in the sense that it would be open to you if you read Engineers and you thought, yep, Justice Isaacs has got this right. As a High Court judge, that would be your right to take things back to Engineers and agree in that instance. But to keep things simple, we'll start with, as near as we can, looking at these 4 sections through the lens of the current state of play. And then if we've got time after that, then we can broaden things out and we can think about whether people have got different views about Australian federalism more broadly, and how that might affect, if you were in the shoes of a High Court judge giving judgment, whether that might change the approach that you take. But we'll start with more the current state of play, just to keep things easier. So step 1, are we dealing with Commonwealth law that the states are seeking immunity from, or are we dealing with state law that Commonwealth is seeking immunity from? in the chat. Okay, so step one, are we seeking, are we Commonwealth law seeking immunity from, and states are seeking immunity from it, or are we a state law and the Commonwealth is seeking immunity from that law?
It's a Commonwealth law.
Yep. So Commonwealth law, and states in particular, it sounds like Queensland and Victoria are having some troubles. What I might do, let's do it like this. So I want to do, I want us to use Chief Justice French's 6 ideas, because I think that that's a really good starting point. So I'm just making a new document up, and I don't know if my screen has shared into it or not. So can you guys see the screen with the table in it, or is it still on the hypothetical?
Just on the hypothetical.
Cool. Alrighty. I'll swap the screen over in a minute. Okay, so I've got the first idea is that all employers have to give priority to ex-service personnel when making new hires, regardless of the position. And so what I'd like us to do is work through Chief Justice French's ideas in Clark, in relation to this idea that if you're an employer, whether state government or not, you have to give priority to employing ex-service personnel. So does that particular section single out one or more states and impose a special burden on them?
I think it's across Australia, so just
Yep.
not 2 states.
Yeah,
It's
so
uniform.
it's broad, and it applies to all employers, whether they're state government or not. So it's not something that singles out one or more states. Is it a law of general application, but still imposes a particular burden on the states?
Not necessarily, because they're employing anyway someone. So they're not creating something, new jobs. There's a role there. They just have to give a priority. So I don't see an extra expenditure coming because they have to employ these people. They don't have to create a new job. The act says when it's only employing new. They have to give priority for the roles. That's all they have to do. They don't have to create or employ. There's nothing enforcing on them.
Okay.
It's only new jobs.
Yep. So this argument that it's fine, especially thinking about it through a financial lens, the position was already there. The state government's already committed to paying that salary. And so whether they have to employ an ex-military person or not doesn't create a new burden. Is that what you're arguing?
Yeah, that's right. I think that's what I was thinking in my mind. Yeah.
Okay.
Jacob, wouldn't there be a flow-on effect from that? Because if you're filling all the positions with ex-defence personnel, the state has to be responsible at some point for all the people that are then displaced and unemployed.
As in, so if you're
From
a civilian
social
person,
security, yes, from a say I'm a civilian person and a defence person gets the job over me, well then I'm going to have to come back to my state government and say, well, I need some money.
yeah.
So that's a burden on the state because they're going to have to support their civilian displaced workers.
Let's say.
I have a different opinion here.
Yep. Go ahead.
I think in terms of employment, the state government is not responsible. So if you're unemployment again, it goes back to the federal government. So you seek money for a few. So I don't see a point. How does it affects the state government? So if a civilian is not employed, so there's no responsibility on the state government. So that's a federal government.
So in terms of thinking specifically about social support, Centrelink, job seeker, those sorts of things, you're right. It's a federal responsibility. But in terms of thinking about employment and unemployment are still things that are very much that state governments pay attention to and care about as well when they think about payroll tax and those sorts of avenues and I mean, this is drawing it probably too long a bow, but even thinking about state governments predominantly being responsible for crime and housing and all these sorts of things. These are still social issues that are related to employment as well, even though it's not necessarily the fiscal unemployment payments, let's say. What I'd like us to really focus on in thinking about whether there's a particular burden or disability on the states, what this provision does is say that employers, and if it's a state government, the state government employer has to give priority to ex-service personnel. And so even if that position was going to be there regardless, the law tries to dictate who the state government should be employing. And so if you had a scenario where you had a person who was very qualified for the job, a civilian person who was very qualified for the job, and an ex-service person who wasn't really qualified for the job. The reading of this section is that the ex-service personnel needs to be given the job anyway. And so even if financially the impact's the same, there's this argument that the law poses a particular burden because it's dictating to the states who they can employ into government positions, and that's something that potentially poses a particular issue for them. In the chat, there's the question of would it be discrimination, and here, arguably, and here's the thing, right, with discrimination is that, do you mean discrimination of the states as opposed to, there are other workforce discrimination concerns as well?
Probably more discrimination with who they're actually employing.
As in, so like would a a civilian person who missed out on the job say, I've been discriminated against because I'm not ex-military?
Yeah, yeah. Would it
I
fall under
mean,
that or not really?
it could be in its own sense. When we're thinking purely on intergovernmental immunity, that's not really the kind of discrimination that we're really thinking about. What we're thinking about is, you're right in that it's a sense of differential treatment, but it's differential treatment when you compare one state versus another state, or states as a collective versus, say, private enterprise. And so in that regard, it's not necessarily discriminatory. It's something that has general application. But when you think about states' capacity to govern, it's, if you're the state government, you're making the argument that this is a law that's tying your hands about who you have in your employment, and it's at any position. So if you're running a state hospital, public hospital, and you need a new heart surgeon, and then someone who has got no medical training but is ex-service personnel says, I'd like to try my hand at that. You're on a broad reading of that, you have to give them the job. And so that's more the concern, rather than whether it's discriminatory per se.
I didn't realize it was specified to jobs with specified skills, I suppose. I probably wouldn't go for the heart surgeon that had no experience.
Well, but anyway, it's
Is
an
it not
ambiguous section as
priority?
it is. But so what's that? Sorry?
Sorry, it doesn't say that. I mean, I'm sure the state government will not take someone because it's just a priority. I think it just says priority. It doesn't say merits. So it's not compromising any merits here. So if there's 2 persons or 3 persons came on same level of the merits on the benchmarking, and they all are good to go, but there's only one position, that's where you give priority. It doesn't say that you have to give it to them. It doesn't say must. It says priority. So I'm just reading as just, if there's a benchmark, they're qualified, they're equally merited, and then you give them a job because they ex-defense personnel or an army person, but it doesn't say to compromise the merits. That's what I read. It just says priority. It doesn't say must.
Okay, yeah, that's a fair reading, and I suppose I'm trying to push this to its extreme to highlight a point in that, and maybe it will help it make clear to look at some of these further questions as well. But the idea that imposing a burden or disability on the states doesn't just have to be a financial one. What we can be interested in is their ability to choose who to employ in these key government positions, right? And thinking about, I chose heart surgeon because it's one that is, you really want to be able to choose the clearly best person for the job. But really what would be more an issue are key governance positions. So a minister choosing their chief of staff, cabinet secretaries, all these top level bureaucratic positions where qualifications and expertise and experience are maybe less clear or less tangible. There's an issue there that, and the courts have recognized that in these high level government positions, it's important that states have the opportunity to dictate employment on their own terms, and that's what's the burden or the potential issue, rather than just, you know, does it cost them any extra money per se. And we see similar themes arising in terms of whether law affects the state's exercise of their functions. So things like appointments to judicial positions, things like key public officers, like let's say chair of anti-corruption watchdogs or Crime and Corruption Commission, those sorts of high-level executive roles. It's important that the states are able to choose who they want for those positions. And their argument would be that giving priority, even if it is just priority rather than a forced employment, it ties their hands in a way that is not consistent with their ability to actually govern. Does that make sense? In the chat as well, would it be unfair to give one demographic favor over another? I mean, I think that comes back to our discrimination discussion before. I think there's an argument that on a personal level, some of this stuff is discriminatory, but from the perspective of state governance, it's not necessarily the issue that we're pursuing. Muddy sense in the chat. Okay, let's think about this, right? So state governments do a whole range of jobs, and it's their right as sovereign constitutional entities to choose who they want to fill those positions. You know, if you're the Premier of Queensland, you get to choose who your chief of staff is, and you know, as a behind the scenes role, that's really important. That's someone who gets trusted with giving the Premier briefs, managing a lot of the kind of day-to-day activities, handling coordination between different departments, different ministers, or, you know, it's a really critical role. And so it's recognized that the Premier should get to choose who they want to fill that role. It should be someone that they trust and respect and think would do a good job. The court has recognized, and I'm thinking in particular about Oz Education or the Industrial Relations Act case, the High Court recognizing that it's not the Commonwealth's place to step in and say, to put restrictions or interfere in some way about how state governments make the decisions about who they choose, especially in those high level governance or executive roles. What the state governments would be arguing here is that this law falls victim of a similar problem, right? It's requiring them, even if it's just priority, even if it's just doesn't absolutely require them to employ ex-service personnel, it's putting an additional limitation or constraint on them in deciding who gets these really important roles within government that potentially have a huge impact on the way that the government of the day goes about its business. And so when we think about whether the law affects the exercise of their functions, I think you'd have a pretty strong argument that it does, because it's putting this extra limitation on the way that they go about their business. Whether it puts a particular burden or disability on the states, similar issue, right? It's putting something onto them that is potentially it affects the way that they make their employment decisions, and then in turn affects the way that they go about the business of governing. And so if you were the state government, you would very much argue that this is something that is putting a burden or disability on the states because it's affecting their ability to employ who they want to employ, basically. Of course, if you're the Commonwealth government, you would argue that it's not. You'd make the argument that it's. I guess you'd say that it doesn't require you to definitely employ it. You just have to give priority. But even that, it's still adding something into the mix that state governments shouldn't necessarily have to have added into the mix. When we think about the nature of the capacity or the functions that are so affected, there you could maybe make the argument that if you were the Commonwealth, you'd try and minimize the impact of that decision. You'd say, well, look, they've still got choice. It's only priority. It's not a mandate, those sorts of things. But the argument is still very much there that this is something that's tying state government's hands in a way that they shouldn't be tied. If this any position whatsoever wasn't there, if it was just unskilled work or work not requiring qualification or something like that, then there would be a stronger argument that the law doesn't impose some sort of particular burden on the states, because the court has been willing to recognize the issue at the kind of higher governance level things. They're not necessarily too concerned about lower levels within the public service. So maybe that's, if you're the Commonwealth, you take that clause out and you start to get something that's a bit less restrictive. But if you're the state government, your argument very much is that even priority is too much of an interference in the way that they go about their business. Does that help clarify, where the argument goes with that one? You're welcome to disagree with the interpretation. You're welcome to say, no, I still think that it's actually not that big a burden. But I want you to at least understand what the argument is. Let's jump across to number 4. So the fourth one on that state governments must ensure that their departments employ all ex-service personnel who don't have full-time employment, even if this means displacing other employees. So does this law single out one or more states and impose a special burden?
I think it's uniform. It's across Australia.
It's uniform across the states but it still singles out the states, right? So one or more can include all six. And so it imposes a special burden on the states as opposed to private business. So it singles out one or more states. It doesn't, you're right that it doesn't it doesn't explicitly discriminate between them. But in terms of states being treated differently compared to private entities, it still is imposing a particular burden. What about even if we characterize it as something being of general application in
Sorry,
operation?
Jacob, I think it was frozen for the last minute or so.
Okay, sorry about that. I don't know what's happening with the connection tonight. So you're right that it doesn't single out a particular state and doesn't discriminate between the states explicitly. But in terms of imposing something specific to the states compared to private employers, it's still singling out and imposing a particular burden on them. And so that's why you'd still say that it's still singling out one or more states. It's imposing a special burden on the states. Even if you could argue that it was of general application, the facts looking into the second question, is it of general application but imposes a particular burden in operation? We've seen in the facts that Queensland and Victoria have a disproportionate number of service people entering those states. So in operation, it's discriminatory in effect, even if you argued that it's not explicitly discriminating between the states. So we'd have strong arguments there. Does this affect the exercise of constitutional powers or affect their ability to exercise their functions? So here's a law that's ensuring that their departments employ all ex-service personnel who don't have a job by a particular date, and even if that means firing other employees to make that happen. Does that affect their exercise of their functions? A vote for yes in the chat. So the argument would be that another vote for yes. The argument would be, and it's following a similar argument to what I've presented to you before, although hopefully the effect is a bit clearer, especially this clause of displacing other employees, right? So it's telling the state government, you've got to get ex-service personnel into jobs and within your departments. You've got to fire people who are already there in order to make it happen, if that's what it takes. And that's when you look at the industrial relations case in particular, thinking about the number of employees and conditions of employment and termination of employment, that was something that the High Court was very much willing to recognise as saying that's going too far. It's not the Commonwealth's position to tell state governments who they should be firing or when they should be firing people. So again, especially thinking at those kind of higher level executive office positions, that's something that the court, you would expect, would be willing to recognize and say, no, that's too far. That affects the state's ability to exercise their functions as a government. So you'd expect that would be a pretty strong yes. Nature of the capacity or functions so affected. Again, it's coming to this idea of state executive function, being able to have who they want, the people that they want in government, or assisting government and making these important decisions. That's fundamental to the nature of any government, but in this instance, the state governments. And so you'd make an argument there around it goes to the capacity or function so affected are these core governance functions about who is in especially these higher levels of the departments. You could make the counter argument, I suppose, if you're the Commonwealth, that it doesn't specify where within the department people have to be replaced, if that's what it takes. And so you could say that this law doesn't have to affect higher level functions, it can affect the lower levels of the public service. So if you're the Commonwealth trying to minimize it, that's where you would take that. But it's a slippery slope in arguing that the Commonwealth can dictate to the states who they should be hiring and firing. And subject matter, we haven't really touched on that, but the facts tell us that the states accept that this would be valid under the defence power. So we have this characterisation that this is a law with respect to defence. You could argue that defence is one that gives the Commonwealth a bit more leeway. But even then, it's not necessarily that something that authorises discriminatory application, unless it was something that was really core or fundamental to the war effort. And so taking this multifactorial approach that Chief Justice French recommends, you'd have a pretty strong argument that number 4 would be invalid, because it infringes this implied intergovernmental immunity. The problems really start to add up. I think even at 1, which is the most general or probably least problematic, the states would have a reasonably strong argument, but there've been some good arguments presented for how the Commonwealth could counter that or minimize that. But going into 2 and 3 and especially 4, the states get progressively stronger arguments to say that this is a law that is infringing the implied intergovernmental immunities. I'm conscious that we've gone past the 8 o'clock mark. Any final questions or comments? As I said, it is a tough week, and there's so much judicial dissent as well that it's or disagreement about what the right approach is here, how best to think about it. The touchstone, more than anything else, the touchstone I want you to come back to is thinking about, is the law in question inconsistent with either the Commonwealth or the state government's ability to govern, to do the things that it needs to do in government? If you can get that down pat as your starting point, then you can build the extra levels of complexity from there. But any final questions or comments or clarifications? No worries. Alrighty. Well, I'll as I said, I'll pop that sort of cheat sheet up onto Moodle with this recording tomorrow. And then that can serve as another sort of springboard for this week's topic. And yeah, that'll be it. Thank you very much for coming along, everyone. See you next week to talk about what are we talking about next week? Executive power, and in particular looking at Section 61 and some of the ideas around how the Constitution empowers the executive and also tries to place some limitations on what the executive limb of government does. So looking forward to that discussion. I'll see you all next week. Thank you.
Thank you.